Hello, my name is Tina Gote, and I'm presenting my discussion board for school law discussing civil liberties. In the case scenario, Principal Sylvester of Labradorville Primary School faced allegations of improper restraint of a behavioral disordered kindergarten student. Witness testimony stated that the child was bound with duct tape and rope to a desk in the principal's office. The student was restrained for an extended period of time and observed crying for help. Sylvester admitted to using tape on the child's wrists and ankles, but denied using rope. The legal question here is, did Principal Sylvester's actions in restraining the child constitute excessive force, abuse, a violation of the child's constitutional rights or educational rights? The legal concern here is the violation of student safety and his or her welfare. There are limits of appropriate disciplinary actions and restraints. Physical restraints should be at a last resort and only used if a student poses an immediate danger to himself or others. The district had other trained personnel who have previously used de-escalation techniques that have been successful. The use of restraints and isolation of the student with disabilities under state protection laws IDEA mandates appropriate behavioral interventions. The potential violation can leave the school and the principal open to legal liabilities. The question presented is, could the principal be liable for civil or constitutional tort? Why or why not? The principal in this case could be held civilly and constitutionally liable based on the state laws governing student discipline, excessive force, and disability protections. Legal considerations may include civil battery, false imprisonment, child abuse, and federal constitutional claims. The potential violation of the 14th Amendment under due process. These laws protect students from arbitrary and excessive disciplinary action or unreasonable physical discipline in case law Ingram v. Wright of 1977. Excessive force may constitute unreasonable seizure if restraints are not justified under school policy, identified in case Doe v. Hawaii of 1983. False imprisonment. If restraints of the student is not legally justified, it's considered false imprisonment under Wallace v. Boyles of 1997. In addition, potential violations of IDEA and Section 505 is when a staff improperly restrains a student without following an individualized behavioral plan. The school district could be liable under federal disability laws. Potential violations of child abuse and under mandatory reporting laws is intentionally infliction of physical or mental injury, state statutes. So when it comes to these cases, these are the potential laws that have been a violation, that has violated the students' due process rights, as well as their civil liberties when it comes to their disability under IDEA, as well as the potential violation of child abuse mandatory reporting laws. So if you, as a mandatory reporter, a teacher, sees these things happening, you must report. And a failure to do so is a violation of the law. Okay, and this concludes my presentation. So yes, this principal has violated the child's rights.